We are live, ma'am. Now we will start the
Okay.
session.
Okay.
Warm happy evening to all the participants who have joined us to gain the knowledge. I am Nirmal Kumar Jain, a law student and the founder of Law Gardener. On behalf of Law Gardener and team, I welcome Advocate Nayantara Sanyal, who have come here and gave their time from their busy schedule to share their knowledge on intellectual property, post-COVID scenario and its effect on startups. I would I would also like to welcome all the participants, which include lawyers, law students, and a common man. Before starting the session, I request Miss Ananya to introduce our guest for the day.
Good evening, everyone. Ms. Nayantara Sanyal is a corporate commercial lawyer who specializes in intellectual property rights, litigation, and consultant. She graduated from a prestigious government law college, Mumbai, in 2011 and started her career as a part of a corporate commercial litigation team at Khaitan and Company, one among the top three law firms in India. Ms. Sanyal started with the, with their work with Delhi office and thereafter moved to Mumbai office. Subsequently, she moved to Anand and Anand, the topmost intellectual property boutique law firm in India, to join their intellectual property litigation team under the guidance of Mr. Praveen Anand. While working with Anand and Anand, she dealt extensively with contentious IP matters, working on the landmark cases including pharmaceutical patent infringement, mechanical patent infringement, industrial design infringement, infringement under the Plant Varieties and Biodiversity Act. Copyright infringement in the music industry, cinematographic industry. She has also, in her previous position, worked extensively with regards to the creator moral rights, personality regards of actors such as Amitabh Bachchan and Salman Khan, and personality rights of the singers such as Daler Mehndi, as well as with the production house such as Dhamma Production, Yashraj Film Production. In the cinematographic industry, she has also dealt with misrepresentation of the geographical indicators in addition to the passing of an infringement of trademarks matter. In 2015, upon shifting to Kerala, Ms. Sanyal joined Elastic Global as associate partner of the Cochin office. She set up and runs Elastic Global Cochin practice. Under Ms. Sanyal, able leadership, the Cochin office has established an undeniable presence for itself in Kerala, and it's handling the corporate commercial intellectual property portfolios of some of the well-known and established business houses in Kerala. Cochin office also enjoy a working relationship with R&D department of number of industries operated by Kerala government, such as the Kerala Rubber Board. The Cochin office also worked closely with startups and works closely with them to help them identify, register, and maintain robust IP portfolios, as well as providing advisory for merger and acquisition, investment, and such other corporate commercial transaction matter. Thank you so much.
Thank you, Ananya, for such a warm introduction. As we know that the intellectual property are the precious assets for a company. It may be a startup or a year-old company. During the time of pandemic, a question was raised to waive the IP rates over the vaccine and other medical supplies to increase the production for fighting against the COVID. To understand the effects over the startups, we have gathered here. Now I request ma'am to take the session further.
Good evening, everyone. It's a pleasure to have this opportunity to speak to you guys. Am I audible to everybody? Is there a lag?
No, you are audible, ma'am.
Okay, great. It's not a very long session. It is going to only be about a 20-25 minutes long session. After that, I'm open to Q&As. Again, please not for very long though. So we've we're coming to the closing end of the second year of COVID in a scenario where companies are closing down, startups are getting affected, investment funds are getting affected. However, we are seeing there is still a branch of or a few companies that are doing fairly well with regard to their valuations, with regard to surviving the COVID environment. So the COVID-19 pandemic has affected people and businesses alike. However, one of the main challenges during the pandemic was the absence of approved vaccines, treatments, and cures, as we all know that. The main reason for this is the reducing effort in the research and development in the fields of science and technology, which in turn resulted in the scientists from around the globe scrambling to find a cure for the coronavirus. I'll talk about this, I'll touch upon this overall at a slightly later point in the um in the session. uh, what I want to start with primarily is that how the pandemic continues to wreak havoc across the globe, and we have seen international cooperation in sharing medicines, PPE kits, technology, information, vaccine research, immunology research, etc. This has been transgovernmental across borders, and this is probably one of the first times the globe has come together, people have come together as a species, as humanity, to find a cure, to work together to find a cure for the common enemy being the coronavirus. Governments are actively discussing things like compulsory licensing, creation of a public patent pool, etc. You have institutes like the Serum Institute that has announced that it won't file for patents, but now over the research and the manufacturing undertaken by them. So we have all of this information. We are seeing all of these governments. We are seeing all of these institutes and private companies come together, and everybody's talking about intellectual property rights and how they're giving it up. So for often it might be confused as to what is the big deal. Are we just not talking about uh, a simple name? Is it not simply a technology? What is the big deal about it? So for us to be able to understand that, we need to understand why it's so important to protect our IP. Now, if you're going to look at it from the point of view of the startup culture, what is important to know is that because rather from the onset of COVID-19, um, the investment valuations in India, the amount of investment coming in has dropped to 0.33 billion in March 2020 from 1.73 billion in March 2019, which is a fall of nearly 81%. Given the global pandemic scale and the uncertain economic situation spurred by it, there is a strong likelihood that fundraising for startups would become a significant challenge in the future, since various investors may choose to focus their future funds deployments only in the existing portfolio of companies to ensure that they are able to tide over the global crisis. Remember, when I started the talk, I said that there are certain companies that seem to have tided over the global pandemic phase. Would anybody be able to name a few? You can put it in the chat. Anybody? All right. Great participation, guys. So there are companies like Amazon, which maintained its number one position with regard to valuation and grew by 64% in this financial year. You have Apple that came in at number two. You have Tesla at 47. All these are all companies that have shown a growth, and you also have some new entries into this field. So that means companies that have started post 2019 that are now valued in some of the highest valuations in the world. You have companies like Zoom, AMD, and Spotify. So clearly, COVID has not affected everybody equally. What can be seen is that against a backdrop of continuing uncertainty, companies looking to the long term, um, consistently investing in marketing and brand building, have managed to stave off the worst of the crisis, which is why we say it is so important that we focus on our IP, we focus on our brand, we focus on the on brand recognition, on market share, etc. So what is intellectual property right per se is often a question I get asked. And is an idea an intellectual property? Can I protect an idea? So let's start from there. So, intellectual property is a product of human intellect. Intellectual property rights is the framework which protects the interests of the innovators and which in turn ensures them that their intellectual property will be protected, and which then again has a triggering effect of furthering innovation. Thus, intellectual property is the driver for innovation and plays a central role in the advancement of an economy. So Indian under the Indian in the Indian scenario, your intellectual property rights are recognized under the following statutes: the Indian Patent Act 1970, which protects your art, processes, methods, or manner of manufacture, machines, apparatus, or other articles, substances produced by manufacturer, and includes a new and useful improvement of any of them. The Trademark Act, which protects words, symbols, logos, slogans, packaging, and any other mechanism or mark which helps identify the goods or services of one person from another person, or I helps identify the source of a product or a service. The Copyright Act 1957 protects paintings, sculptures, drawings, literary works, musical works, sound recordings, etc. The Design Act 2000 protects the shape, configuration, and patterns. Geographical indications, as its name says, protects geographical indicators such as, to give you a few examples, Palakkad rice is one. Then you have the basmati rice. So any particular product that is known uh, for its qualities based on the geographical location of that product is generally protected under the Geographical Indications Act. Then there is the Semiconductor and Integrated Circuits Layout Designs Act, which protects your layout designs for integrated circuits. Then you have the Biological Diversities Act and the Protection of Plant Varieties Act. So now we have a lot of different acts protecting different minute niche parts of intellectual property. So why is it important for a startup though? So the driving force behind a startup is basically a novel idea. So it is the implementation of that idea that transforms a small startup into a multi-billion dollar business. Novel ideas which are implemented in the form of brand names, goods, services, innovations, etc., are what is protected under the current IP regime. Thus, IP rights play a key role in every sector and have become the basis of a crucial investment decision for multiple investment houses. Registration of intellectual property accords stronger protection and leverages the business to gain access to much needed capital. IPR for any company, especially a startup, is an intangible asset. So it is an asset base that, yes, does not have any physical form, but it's also one of the only asset bases that does not depreciate. That means you, as a startup, you could have, or as a company, you could have invested in uh, offices and cars and infrastructure. And while all of that is part of your capital asset, with every year you have to account for depreciation of that asset. Whereas when you invest in intellectual property, that is, if you invest in your brand name or your copyright, or in patenting your proprietary information or technology, you, in that case, that would, as the years pass, that grows in value rather than depreciate, which is why it becomes such an important asset base for any company, more so startups. Moreover, investors are more likely to acquire a startup which possesses well protected IPR, as it's a form of a greater resource while competing with industry giants. So now, to give you an example, if you have um, company, a startup that has a special formulation for uh, a toothpaste that is specifically will clean your teeth or will make your teeth whiter in X amount of days, and that is a patented proprietary formulation. When that startup enters the market, it automatically creates a niche for itself because it is a proprietary technology that is over and above the current industry standard base, which is why it is patented, and that gives that startup that much an edge over, say a Palmolive, a Close Up, or a Colgate, or some other name brand. Therefore, it is crucial for startups to protect its IP, as over 80% of the valuation of a business depends on its IP portfolio. Any questions so far? If anybody wants to ask anything, Nirmal?
Ma'am, the questions will be asked in the chat box, maybe in the end of the session. Uh,
Okay.
Like end of the means
It's
after
just
you.
a really boring format to hear me talk. It makes a lot more sense if, as I finish sections, if they could, if there are queries, I'm happy to take them. Because just listening to me talk for 25 minutes will put everybody to sleep.
We have got some questions during the registration. If you want, we can deal with this.
No, not. I'm saying with regard to this section, if there is any questions, please put it out there. Otherwise, we can proceed. It's just
No, ma'am, there is
participation
no
counts
such
out.
questions. There is no such questions right
Okay,
now.
great. Okay, then I will proceed.
Yes, ma'am.
So now that we understand what is IP, how is it important for startups, we can look into the benefits of IPR and why it's so important um, in a post-COVID scenario. So, when you're obtaining protection for the company logo, what that ensures is that the integrity of the brand, and it also creates a strong market presence, brand identity, and product differentiation ability, thereby creating a space in the mind of the consumer for your brand. Now, if you have a brand that has a loyal following, you're bound to then have a much greater valuation than a brand um, that may be popular but is not um, as does not have as loyal a fan base. And when you protect your trademark, when you protect your brand identity, you enable that kind of brand recognition to occur in the market, because you are saying that image, that word, that logo is your proprietary information, is belongs to only you, to the exclusion of all others. So that again helps you enhance the commercial value of the company. Patented innovations are a valuable asset for companies. It secures market position and ensures financial returns on commercially successful innovations. A startup with a single valuable patent can acquire many more quickly during the process of innovation, and thereby making them a more attractive buy for investors. So, if I were to talk to you in the current scenario with regard to COVID, you have companies like Serum India, which have said uh, we're not going to patent any of this. In fact, giving up on patents is commonly seen as a mark of being benevolent, or as a philanthropic act, because you are basically saying this information, or this um, product that I developed through research and through the money that I spent, I'm putting it out there in public without wanting any gain for it. Another example for this would be penicillin. When penicillin was discovered, they didn't or rather, when it was synthesized, the process was not patented, so that the antibiotic would be available for all. Um, then Many startups put in an abundance of creativity in developing the most attractive yet productive website software applications which are copyrightable. Since their website and software applications are the backbone of the majority of startups, special care and attention is required to be given towards their protection. If they are not protected within the right time frame and in the right using the right mechanisms, there may be a chance that a competitor may exploit their expression of the idea. Now, this is very important because we are not protecting the idea. IP does not protect the idea, it protects the implementation or the execution of the idea. And that is very, very important in today's world where you have uh, most of your innovation is software based. Yes, of course, there are. Pharmaceutical innovations, there are mechanical hardware innovations, etc. But the majority, the large chunk of innovations or patent filing now comes from the software sector. And strangely, patents are not allowed on software. You have to file it under copyrights. So, being able to understand the manner in which to word it, the manner in which to claim protection, etc., becomes very important, which is why it is very important for startups to start working with proper IP lawyers from the very get go. Intellectual property rights prevents third party infringements and protects the owner from costly litigation. Protecting your intellectual property shows proof of ownership in a court of law, thus making it easier to prove that the IP belongs to you. So, uh, by virtue of you being a registered trademark holder, the assumption in a court of law is that that belongs to you. That so if there is someone infringing your right, they have to prove that they are not infringing your trademark, and not vice versa, as is true in the case of passing off. You obtain greater negotiating power with when collaborating with other companies, or if you're looking for a merger, or if there is a bid for acquisition. The ability of the founder or the CEO to be able to negotiate a better deal for the existing shareholders or the co-founders, or as the case may be, is much more when you have a stronger IP portfolio, because that becomes an asset base that is not dependent upon your market trends, in the sense with regard to like your real estate valuations, or the fact that machinery is subject to wear and tear, is subject to depreciation, etc. So if you are a company that is consistently invested in building and protecting your brand or your intellectual property, you will always have that as an asset base, irrespective of uh, the condition of your tangible assets or your capital assets. Having a strong intellectual property portfolio attracts investments, partners, and supports business expansion, as it demonstrates that a company has a high level of technical expertise. You gain you can gain revenues through licensing, franchising, or other IP transactions. So, to give you an example, if a startup owns a particular IP, that ownership allows the startup to make money from licensing that IP, selling the IP, or transferring those rights. So, if you have a patent, but you don't have the resources to commercialize that patent, or it's a patent that is of older technology that need not just lie unused. You can then license that technology, be it a slightly older patent, or be it the fact that you don't have the money to commercialize your technology. You can still turn it into a revenue stream, which is very, very important for any company to have, particularly in this scenario. So what would be the risks involved with not protecting your intellectual property? So, one of the biggest risks involved with not protecting intellectual property is third-party infringements. So, with regard to trademarks, if I were to give you an example, is If the mark is not registered, the person claiming prior use, or the person who can show that they have uh, created an impression in the minds of the consuming public before, you will claim right over your trademark, irrespective of how much time or effort you may have put in developing that trademark, in popularizing that trademark. All of that is immaterial. It's a matter of, so the burden of proof is on you to prove that that is rightfully yours. Whereas when you have a trademark registration, the assumption is that that mark rightfully first belongs to you and not the infringer. So the infringer or the impugned mark has to prove that they are not infringing, which I know is a technicality, and most people think that, oh my God, what difference will that make? But um, as a practicing IP lawyer, I will tell you it makes a huge difference. It is the difference between getting an interim injunction in your first hearing and the difference of not getting an injunction. If you don't get an injunction, there is no point in filing an intellectual property lawsuit. Without your interim injunction, you will be stuck in the process of adjournments, hearings, of uh, evidence hearings, and it follows the long course of a trial. Whereas when you have a registration, you get your injunction, so you get your immediate relief in most cases. Of course, there are other parameters to look at, but in most cases, the registration of an intellectual property is proof of its ownership. Thus, startups should protect their IP not only for proof of ownership of the IP, but also to prevent third parties from using their IP to avoid losing money on litigation battles. Uh, so the government is really, really pushing for having a very cohesive and supportive um, intellectual property registration mechanism, or ecosystem for startups specifically, because like I said, if innovators have their ideas protected, I rather have the execution of their ideas protected, have their the fruits are able to enjoy the fruits of their labor, it is more likely that they will be more inspired, or it will inspire more people to get into the fields of research, to look for innovative solutions, to to basically make it a better place for both the consumer and the economy. So there are a few schemes that the government of India promotes, such as there is the Startup Intellectual Property Protection, which is SIP, for encouraging innovation and creativity of startups. The scheme facilitates the startups to file applications for patents, designs, and trademarks through registered facilitators in appropriate IP offices by paying only the official fees. So you don't have to pay the lawyer fees, you only pay the official fee. Then expedited patent examinations, this is a mechanism that is available only to startups, which means if your company has existed for more than 7 years, or you have a turnover of more than 10 crores, you cannot you cannot file for an expedited patent examination. It will follow the process, and sometimes that can take up to 2 years for you to get an examination report. So then there again, the government is trying to facilitate, make it easier for startups to get patents. There is of course discounted filing fee options, which can give up to 80% discount to startups. There is the Startup India Initiative and Make in India Initiative, which all uh, not only help incubate startups with promising IP portfolios, but also enables startups to identify their IP, helps them access lawyers to get the registrations or the necessary protections in place, etc. So the government is really, really trying very hard to help startups and build India into a IP friendly country, because India does have a bit of a reputation outside with regard to having a very lax approach towards intellectual property. It is changing. It is changing quickly. Then there is the accelerating growth of new India's innovations and self for IPR promotion and management. Some of the strategies for protection of and exploitation of IPR for startups would be, you can make intellectual property protection a priority, because the first step for any startup is to evaluate and prioritize their IP rights involved in the business. Depending upon the type of industry you're involved in, IP rights play a pivotal role in your valuation. Failure to identify or prioritize IP rights is likely to create problems for startup businesses, especially during negotiations with future investors. Sometimes IP rights are the only assets that are available with startups. The next strategy would be to register intellectual property rights immediately. A registered IP carries greater value and acts as evidence of use of the IP before courts as well as enforcement agencies. Due diligence of IP rights. For any startup, it is indispensable that it does not violate IP rights of any other person. This will ensure safety from any unwarranted litigation or legal actions which can thwart its business activities. This makes it more important for startups to make careful IP decisions in the initial phase and conduct proper due diligences of IP rights. Agreements related to intellectual property. Again, this, I cannot stress this enough. It is very important to have proper agreements in place with regard to intellectual property, even if you think they are, my friends, they are family, etc. Please put all corporate matters, all business matters, in all matters with money and with value in writing through proper agreements or contracts. So it is pertinent to note that having a proper documentation in the form of agreements like non-disclosure agreements, agreements with employees or independent contractors can make all the difference between the success and failure of startups. Finally, there is the national phase which of IPR, which is often we get asked, we want to file for international patents while or international trademarks while we're filing for Indian trademarks. Now, in such a situation, international patents or international filings can prove to be very expensive, and that often demotivates startups to pursue IP protection. So what I always say is it is a good start to apply for a domestic patent or trademark or copyright, and then as the company scales up, it can set aside a budget for patent or trademark or copyright in the international market. And it is important to note that if you don't have, in a number of cases, if you don't have an Indian registration or if you don't have a home country registration, you cannot avail of benefits of international registration under certain treaties and conventions. So protecting IP becomes very, very important, not only at the grassroots level for generating income, to ensuring future income, to the point of helping you expand and taking your business global. The process of So in conclusion, the process of bringing a new startup business to life, uh, to launching new products to the marketplace, can be an exciting time. However, many startups are so focused on bringing a new product or service to market, they fail to take the necessary steps to protect the associated IP. Failure to put an IP plan in place can cripple valuation and expose the startup to potential third party infringement risks. In contrast, startups can protect and exploit their IP assets to build value and revenue by developing an IP plan as part of their conception, which shall allow them to go a long way in becoming a successful enterprise. Thank you. Yeah, that's about it.
Yes, ma'am. Uh, Thank you, ma'am. And we will start with the question and Q&A. Um,
Sure.
yeah. So first question is like, what are the challenges that the startup are facing in the time of this pandemic?
So, like I said, one of the biggest challenges is that there isn't enough funds available, one, and two, people who do have the funds, so hedge funds which who do have funds are preferring tried and tested brands. So your brands like I named, Amazon, Apple, Tesla, they all started as small startups, right? Nobody starts out being an Apple. You start up in a garage somewhere and then you take it forward, right? So they have consistently invested in building their brand, irrespective of whether they were a small two-person enterprise or if they were a $1 billion enterprise. Depending upon the the capital available with them, they have allocated certain funds for building a brand, which is why today investors would find companies like that more valuable, because despite COVID, it hasn't really affected their growth. Right. So
Yes, ma'am.
it's
Yes, ma'am.
because if you're an Apple computer user or any Apple product user, you're going to be one of those fanatics who say, no, cheap, we don't want Android Vanda. So that is the fanballing, that is the power of a brand. So if you
Yes,
start building that at your grassroots level, it makes it much easier. But because lots of startups don't do that, a challenge faced by them is there is a lack of funds now, and nobody's going to play the high risk game anymore, because everybody knows we're heading towards, well, a lot of things. So
yes, yes, ma'am. Rightly said, ma'am. So, like, how can so if there is any problem like while registering the IPs, how can they overcome those problems, ma'am?
well, that's a very broad question, no, Nirmal? Isn't that like saying, if I commit a crime, what would be my punishment? That, I mean, depends upon what the crime is, what is the mens rea. You have to look at all of that exactly the same way when you're dealing with IP. You have to see what is the IP, what is the challenge. Is it a Section 9A issue? Like, is it a issue with regard to trademark being descriptive? Is it an issue of trademark being deceptively similar? Is it a lack of innovation under a patent? Is there a plagiarism issue under copyright? So you have to see what it is. Only then can you go ahead. You can't just say what are the challenges and what are the solutions.
Yes, ma'am. So it basically depend upon the practical circumstances what they are facing.
Absolutely, absolutely.
Yes, ma'am. So as we know that majority of them IT sector including, so they have started their work from home policies. So is there any like such a fear that their IPs may be infringed from the work from home policies? If yes, then they
Um,
can how they can prevent it?
okay. So most IP companies or all companies should have work for hire clauses built into their agreements, into their employee agreements. These clauses basically state that anything, irrespective of where it is created, if you are creating any kind of intellectual property asset using company products, using company resources, then it belongs to the company, or during your employ course of employment with the company, it belongs to the company. So if you're talking about an IBM, if you're talking about an Infosys, they already have that in place. And if you're talking about small startups, they're all working from their own garages. So I don't really think there's that much of an issue happening with that.
Yes, ma'am.
And of
So
course, if
we'll
that is the case, that if there is somebody who is finding that their IP is being infringed because of their employees working from home, again, that would depend upon a conversation of what is the IP being infringed, to what extent is it happening, is there a breach of contract, is there a contract in place. So it's a very practical based situation. It's very difficult to answer it theoretically.
yes, ma'am. So we'll move to the next question. So for the patent registration, it usually takes a long time. So during this pandemic, what the government are doing like to foster the registration? Are there any such schemes or implementations?
Nothing.
So like there is no such remedy for that. Since
Nothing.
they have
No,
to.
no. It's taking time. It's going to take time. It's become slower. Yeah, it's there is really, I mean, they're trying their best to clear the backlog. The registries are working very hard, and the registrars are honestly overworked. But yeah, I mean, the people who are actually having to deal with it are dealing with it like champs, but the people who are supposed to be passing the laws and doing the logistics aspect of it aren't really doing a great job. So it, yeah, but then again, you also have to bear in mind, one of the benefits of IP is that when you file the application, your protection starts running from that date. So, you know, irrespective of whether you're granted the IP at a later date or not, you are assumed to have protection, right? So
Yes, ma'am. So, like, are there any like IP laws like as normal how like before COVID, how IP laws used to work? Are the same way they are working, or they have granted some any other things?
of course, they've well, I mean, it COVID has not really affected the prosecution process of it, because it's still, I mean, it's gone online and people are more tech savvy and everything is done paperless, etc. Something that should have happened years ago has happened now because of COVID. But I mean, per se, it hasn't really affected the prosecution process. Of course, timelines have been relaxed a lot because you have lockdowns happening in places, mini lockdowns. There are, areas where courier can't go, so you can't do the service within the stipulated time period. So they're a lot more lenient on those fronts, which really benefits the IP owners. So they're trying their best to make it a very IP friendly or proprietor friendly situation.
Yes, ma'am. So, is there any government schemes to boost the startups, ma'am, during this type as they
Yeah, like I listed the bunch for you. The ones that I mentioned, these are primarily the ones that are focused on startup enabling startups to get your registrations done properly. There are other schemes where, but those are again localized. Depends upon on your state government what is their IP culture. So Kerala has a really good IP culture when it comes to support from the government. So it works a little. I mean, it works better in the sense. A lot of young innovators are encouraged to approach IP lawyers, work with them, figure out their patentability, etc., as opposed to say another tier two city. Like you can't compare a Kerala to a Bombay. That doesn't work. But like say comparing it to like a Coimbatore, etc., it's much better.
so which is the best state for the concerning the IP laws, ma'am? Which has most lenient or a good IP laws for their something like that?
I mean, IP law is a central law. I mean, it's
Yeah,
not a
like
state
maybe some
subject.
schemes, service schemes like that. Yeah.
Um, so you have again, there is UP right now, which is a really really encouraging with its startup culture. So is Haryana. The Kerala does a great job with its IP incubation. Of course, there is Bangalore, and yeah, these are about the standard ones. I don't mention Bombay and Delhi because I think those two places are really, I mean, they've been done numerous times. Like they're leading it in almost everything, so
Every
it
year.
really
Yeah.
doesn't make sense. Yeah.
Yes, ma'am. So we'll move to the next question. As we know, like how can India increase its rank in the International Intellectual Property Index, as in 2020 it decreased to 40th rank from the 2019, which was 36th rank, despite the government is trying to improve the IP laws.
uh One of the first, what really needs to happen is, so the reason it affects us this much is because we don't allow a lot of we're still a very how do I say this, a very social state. We're a socialist state, whereas we still believe in compulsory licensing and affordable health care and all of that. So it's very difficult for a country with India's history and population and issues to suddenly wake up and say, no, I'm going to be number one in IP enforcement. Because then you're going to have to face the reality that life saving drugs can be out of reach for almost 80% of the population, which cannot work. So we have to find a balance between uh, encouraging innovation through protecting IP, etc., and also providing for our teeming millions who don't have that sort of a the ability to access it. Now, are you telling me India's ranking in IP is more important than giving cancer drugs to like the government hospitals?
No,
That can't
no,
be right.
ma'am.
There's a reason
Yeah.
why India is known as the world's pharmacy, right?
Yes. Yes, ma'am.
So yeah, we may have dropped a few points, but okay, we're figuring it out. We're still, at least we're now respecting trademarks a lot more. Where, I mean, look at China. They don't give a shit, do they? They don't care. So at some point, you have to look at your own benefit as well about encouraging. Uh, I think one of the only ways to get India to be ranked higher is to encourage innovation at a local level. So, changing the way we teach in schools, changing the way we do examinations, all of that. Again, we have to create an ecosystem that encourages innovation. You can't expect children who've been taught to, memorize answers. Like, come on, we are all, I mean, you're all law students, you're all giving law exams. We all know how we gave law exams. We read the guide, we know what question is coming, you know what
Yes,
the
ma'am.
answer is, it has to be X number of pages, otherwise, no matter how good your answer is, it doesn't work. So if you're going to work on a system like that, you're not encouraging people to think beyond the box or get out and, innovate. Then it doesn't matter if you have 30,000 schemes helping you to protect that innovation. You're not teaching innovation. So, one of the things I think that need to be done is that's the one way we can grow in the index, rather than try and be more strict with enforcement, or be more trips compliant, etc.
So
But of
basically,
course,
the
this is my
education
2 cents.
system should be improved.
That is the basic takeaway of any
Yeah.
conversation that happens in India, yes. But in this situation, particularly if you want to look at innovation, you have to stop thinking that it'll come only through the lawyers, doctors, and engineers of the world. It comes through creatives, it comes through a lot of aspects.
Yes.
So, yeah, I mean, yes, in short, education needs to change.
Is yeah, from the basics should be changed, then okay, we can think of that we will have a good number of innovators in the future. In the future, yeah.
Correct, correct.
Like that.
Yeah, you also have to encourage that in innovation. So when a child is being innovative, or when you have young innovators who have come up with path-breaking things, like you have the recently they filed a patent for, I can't remember the name of this technology, air mask, where it sanitizes the air from COVID-19. It reduces the ability of the virus to procreate. And it's a young bunch, it's a very young bunch of students who filed for that patent. Now, encouraging students like that, encouraging that sort of innovation makes sense. Yes, make the process for them to get that patent easier. Absolutely, that is important. But also give them funding to take it to the next level, or give funding to someone else who's looking on similar lines. You know what I mean?
Yes, ma'am.
And that can only happen if they get that pattern. So it's a vicious circle.
Yeah. So we'll move to the next question, ma'am.
Sure.
Okay. Can the central government make a patent information public to other production companies in the names of health emergency? It was asked by Kabir Jaiswal.
Yes, there is a provision called compulsory licensing, but again, there are certain requirements for compulsory licensing. It's a very heavily debated topic, particularly in the current scenario, because a patent accords monopoly to the owner to produce and distribute a patented product as they see fit, and to keep all other parties from doing it. So it gives a huge patent holder. So what compulsory licensing is supposed to do is it empowers the government to grant such rights to parties other than the patentee without the consent of the patentee to produce, to manufacture the patented product or use the patented process. Now, the primary objective of something like this is to give access to pharmaceutical products, and especially in those countries, particularly third world and developing countries. So, while on the one side it's kind of viewed as trampling upon the rights of the innovators and investors, particularly because pharmaceuticals are expensive
Ma'am, there is a network
but
issue,
then
ma'am.
again,
We can't hear you.
would you rather have an AstraZeneca make money over the life of another human being? That becomes a moral debate. Sorry, hello.
Ma'am, there is a network issue from past 15 to 20 seconds.
Okay, is it better now?
Yes, ma'am, it is better.
Okay, sorry, did you get the last bit, or I don't know.
Yeah, if you can repeat it last 30 seconds, then yeah, it will be quite good, ma'am.
Sure. So what I was
Sorry.
basically saying is that so like, I don't know if you heard about, so the primary objective for compulsory licensing is to make uh, drugs or make that patented product available. In the current scenario, in your question that you are asking, yes, if it is so it's a question of greater good. So is the greater good of humanity, that is access to healthcare and medicines for all, more important than AstraZeneca and its shareholders making more money? So it's so compulsory licensing comes from there. But yes, the central government can make information or patented information public for a production company if it is felt necessary.
Yes, ma'am. So it's okay. Is there can you tell us the difference between patents and the trademark by Saraswati M?
Okay. Okay. So it's the difference is a bit like apples and oranges. Patents specifically deal with your technology, or they deal with your innovation. For instance, your how can I say this? Patents you deals with your machine apparatus and manufacturing process. So the hardware of an iPad would be patentable, but the name Apple is a trademark. So the a trademark is the brand identity or the brand name that is associated or that identifies the source of a product, whereas a patent protects either the manufacturing process or the product mechanics and the product itself. Trademark protects the appearance of it, the way it is marketed. So that is the basic difference.
Yes, ma'am. So, okay, there's a question by Farid Nisha. Copyright disclaimer is displayed in YouTube channel at the beginning. Is that have anything mandatory to showcase the page?
So that is a question also with to do with contract law. So disclaimers work as contracts, but they are very hard to enforce in a court of law. So they don't particularly they cannot be held to be particularly binding. Okay, but it's more of a source of sort of a warning. um so it depends upon YouTube's policy. In the case of YouTube, they do have a policy which protects copyrighted information. So therefore it becomes beneficial for them to warn content creators or people who are watching movies, etc., that this is copyrighted content, you cannot watch it. Again, it also includes an aspect of cyber law, which deals with the responsibilities of an ISP or an internet service provider, the responsibilities with regard to internet provide, not your just service providers, but your platforms like Facebook and Instagram and YouTube. But it's not mandatory per se, but it is recommended.
Yes, ma'am. So, so how much time it normally takes for a patent to get registered, and is there any speedy process for startups?
Yes, there is a speedy process for startups. Like I mentioned, expedited patent examination is a mechanism that is meant to speed up the process of examination of a patent application. And it is open only to startups. Your How long does it take? It really is very dependent upon what is the patent for, um, how much of prior art exists on the matter, what is the degree of innovation. So it can take anywhere between, say, a year to 2, 3, 4, 5 years. It really depends.
So if in between that 5 years, if there is any infringement of that patent, so before registering it, what will happen, ma'am?
You'll have to go under a procedure of passing off.
Yes, ma'am.
But of course, there are judgments that have now said that even if you have crossed a particular phase, you can claim infringement. So again, it depends upon the degree of infringement, what is the monetary gains, what is the patent that has been applied for, etc. So
Yes, ma'am.
field, etc.
So next question is, in which situation are John Doe orders granted?
Okay, a John Doe order is granted. Okay, so a John Doe order is basically when you don't know about who is infringing. You know there are infringers, but you don't know who they are. So that is, but you need an injunction. So to give you an example, uh, we all, uh, I don't know if everybody, where everybody's from, but in Delhi you have Sarojini Nagar, you have Chandni Chowk, where they sell, you have GK1 market where they sell first copies, which are basically counterfeit branded products. So like a Chanel bag or a Balenciaga boots or whatever. So we know that that infringement is happening, but we do not know where that infringement is happening from. Who is the counterfeiter? Who is facilitating this? Because and we need to know what the source is. We need to stop it at the source. Yes, we will get an infringement against the people selling it, but we also have to get an injunction against the person who's giving it in the market, right? In such a case, you have a John Doe order.
There is a next question called, if any person uploaded movie or song on internet without any pay to investors or creators, so what happens like such thing?
That is violation of copyrights.
Yes, ma'am. So
So they'll have to file for a suit for infringement, or again, I,
it's a
if we
court
are going to
process.
go by the law book's answers, you simply go through for the uh, infringement process. Of course, there are other mechanisms like you can C&Ds are there, you can negotiate, there are arbitrations, depending. But mostly you go to a court of law for an injunction.
Yes, ma'am. So move to the next question. Okay. Do you think COVID came just to promote technology, from Farid Nisha?
Pardon me, to promote technology from Far East Asia.
The name of the person I was just telling that. Okay, she
Oh,
questioned
oh,
that.
sorry.
Okay.
Right, got it. That's a very, very interesting take. I mean, COVID is, I want to believe, a naturally occurring virus. but it has definitely put hit the fast forward button as far as becoming digital India is concerned. So yeah, it has definitely promoted the use of technology, but I don't know if it came just to for that purpose. I think it came because there's global warming, and there are rampant, slaughterhouses that are not managed well, and it's just a culmination of generally bad karma by humanity. But yeah, technology, the boost of technology is probably one of the silver linings, possibly. I don't know if there's a silver lining, but maybe.
Yes, ma'am. So, like, what kind of remedy provided to protect the intellectual property rights of the creator of artistic works like movies, song, etc.?
Copyright registrations.
Yeah, same. Yes, ma'am.
So
We
you
move to the
have
next
to
question.
register your work.
Yes, ma'am. How to stop infringement of IP? Any suggestion for precautionary measures like of protections?
uh Again, infringement of IP is like saying committing a crime. You need to know what IP you're talking about. So IP is the greater circle of a Venn diagram. The smaller circles are your trademark, copyright, patents, and its subsets. So any suggestions on protections, I won't know, Mr. Hinesh, till I know what IP is being infringed.
Yes, ma'am. So we'll move to the next question. If I have anything. Yeah. Okay. Does there is a need of any special tribunals or court to resolve the matters rapidly?
Yes, there already is. So you have the Intellectual Property Board, which is your registrar. Of course, the Intellectual Appellate Board has been scrapped, and now jurisdiction lies with the commercial bench or the commercial court. So there are courts that the Chennai High Court has a specific bench for intellectual property matters. So there are courts, there are tribunals in place that are trying to deal with matters in an efficacious manner. But you also have to understand that for I think every 10,000 people in India, there's one or one and a half judges. So it's just the quantum is not going to be easy to balance out. I mean, if they have to clear out backlog, each judge will have to hear about 100 to 150 cases a day, which is humanly impossible.
Yes,
So
ma'am.
is there a need for more tribunals and more courts? No, there is a need for more judges.
So basically, we need first more judges, then we can go up on the other courts.
Absolutely, absolutely.
So my last question is like, does registering IP it creates a monopoly or it creates a healthy competition, maybe in the domestic or international market?
Oh, this is a very interesting question, because in most cases IP helps you um, create a monopoly for your specific thing. It's not a monopoly for a particular industry or a particular product or anything of that sort. It's only for your intellectual property, so the fruits of your intellectual labor. In that case, if you're going if that definition of IP is looked at, which is the universally accepted one, it encourages competition, because each person wants to innovate and get that aspect of monopoly. Now, to give you an example, IP does not prevent, like the brand name Binani or Binani Cements does not prevent anyone else from dealing in cement. It simply prevents someone else from claiming their product is Binani cement, or claiming that their products have the same benefits as Binani cement.
Yes, ma'am. So I think we have covered all the questions from the comment box and all the registration questions. So before concluding the session, my last question is like, what your advice to the students and the youths to develop in this field, or any other advice you would like to give, ma'am?
Uh, just be, just read. Please don't think uh, an LLB degree with from a college is enough. Like, it's not. In fact, when we get out of law school, when you get out of law school, you will realize law, the actual practice of law has nothing to do with what's taught in law school. It is very different. So please read, go and read commentaries, learn how to research. Please learn that your your strength in a particular language is your key to being a good lawyer. So if you are someone who is strong in English, or if you are someone who is strong in Hindi, or in Marathi, or Gujarati, or Kannada, or Malayalam, or any language, then please read judgments in that language. Make that your forte. Make yourself, because the more you can interpret a language, the more you can understand the intricacies of the language, the easier it is for you to draft, easier it is for you to argue, easier it is for you to interpret the law. It becomes your biggest strength. So please read, and please make your and make don't I meet a lot of lawyers, because I have worked in Bombay and Delhi, and now I'm settled in a Kerala. I meet a lot of lawyers who tell me, "Oh, we're not as comfortable speaking in English. We're not as comfortable conversing like that." It doesn't matter. Don't speak in English then. Speak in the language that makes you comfortable, but be the best in that. Every high court, every district court allows you to practice in your native tongue if you're practicing in that particular jurisdiction. A court in Gujarat will not say you cannot argue in Gujarati. It may not be standard practice, but they will not say
Yeah.
it. So make use that. And
So
please read.
basically,
Please stop thinking Google and Wikipedia are the answer to everything. Please. Please open a damn
yes.
commentary and see what is being written over there.
So
That,
basically,
yes,
we should
that's very
not rely
important.
on Google or Wikipedia, and we should hard work plus smart work upon the books, and should be like, okay,
Yes,
have a control over at least one language to succeed in this legal world.
yes, yes. And
So,
Manupatra is not God. Yeah, fact.
so who is the god, ma'am?
I wouldn't say commentaries. Please get your reference from the Manupatra, but see what the thing actually says, what the case actually says. So I mean, don't read head notes and say this is it. Very different from reading the actual judgment. And the more judgments you read, I promise you, your language will become better.
Yes, ma'am. Thank you
Okay,
for
I
such
think
a
that's what it.
wonderful. Thank you for such a wonderful advice, ma'am. And
Thank you so much for
now,
having me.
now I would like to conclude the session by thanking Advocate Nayantara Sanyal for providing us time for this from the busy schedule and giving us a wonderful and the practical insights about the topic. And I would also like to thank my team and all the participants for participating in the session. And also, do take the vaccines and be safe from this corona pandemic. And that's it.
Yes.
Thank you.
Thank you.
Thank you, ma'am.